Electoral corrupt practices and electoral offences. Disclaimer. This training material is for use in training of election officials. It should not be referred as guidelines of ECI. In case of any variance in this training material, the ECI guidelines or rules or laws shall prevail. Learning outcomes. At the end of the session, the participants will be able to define corrupt practices in connection with an election, explain the electoral offences at an election, differentiate between corrupt practices and electoral offences at an election, classify different types of corrupt practices and electoral offences at an election, interpret various decisions made by honorable courts regarding corrupt practices and electoral offences at an election, identify different sections of the RP Act and IPC with respect to corrupt practices and electoral offences at an election. Background. For democracy to survive, rule of law must prevail. Best persons to be chosen as the people's representatives for proper governance of the country. So, persons of high moral and ethical values should win elections on a positive vote on their own merit and not by the negative vote of process of elimination based on comparative demerits of the candidates. Honorable Supreme Court in Gadak Yashwantrao Kanakrao versus E.V. Alias Balasaheb V.K. Patil has advised and reminded the Indian polity about ethics in the elections. In Gadak Yashwantrao Kanakrao, the SC advised to set the trend for giving information to the electorate up to lower levels and provide congenial atmosphere for a free and fair election. Not to degenerate the election campaign by speeches of top leaders which promotes even violence leading to criminalization of politics. Honorable Supreme Court in S. Subramaniam Balaji versus the Government of Tamil Nadu and others has clarified that corrupt practices under the RP Act 1951 can be committed by candidates and individuals but not by the political parties. Distinction between corrupt practices and electoral offences. Corrupt practices at an election are specified in Section 123 of RP Act 1951. Electoral offences at an election are led both in IPC Chapter 9A and in RP Act 1951 Chapter 3 of Part 7. When a corrupt practice is committed by a candidate or by someone else with his consent, it has the effect of vitiating the whole election and will result in the election of the candidate being declared void. Electoral offences does not have such a fatal bearing on the election result. In a corrupt practice, the whole constituency suffers in as much as the candidate loses his seat and the constituency goes without representation till another election is held. In electoral offences, only the persons committing the electoral offences suffer for their criminal liability. Corrupt practices can be agitated only after the election is over and only in the election petition. Electoral offences can be taken cognizance of as soon as it is committed and tried under the provisions of Code of Criminal Procedure 1973. Corrupt practice entails only certain civil disabilities like disqualification for voting and for contesting elections for certain period. Electoral offences may result in imprisonment or with fine or with both, apart from civil disabilities like disqualification for voting and for contesting elections in the case of certain specified electoral offences. Any person found guilty of corrupt practices can be disqualified, and if so, for what period, is determined by the President of India on the advice of Commission. Corrupt practices. Provisions related to corrupt practices was explained by the Supreme Court in Patangrao Kadam versus Prithviraj Sayaji Rao Yadav Deshmukh. Those indulging in corrupt practices at an election cannot be spared and allowed to pollute the election process, and this purpose is sought to be achieved by the provisions contained in the RP Act 1951. Under Section 123 of RP Act 1951, corrupt practices are bribery, undue influence, systematic appeal on the ground of religion, caste, etc., publication of false statement relating to a candidate, free conveyance of voters, incurring of election expenditure in excess of the prescribed limit, seeking assistance of government servants. Bribery. Corrupt practice under Section 123(1) of RP Act 1951. Electoral offence under Section 171(b) of IPC 1872. The Supreme Court in Ghasi Ram versus Dal Singh held that an offer or promise not made to any particular voter or voters but to the general body or residents without distinguishing between those who were favorably inclined and those who were not was not a corrupt practice. The Supreme Court in Ziauddin Burhanuddin Bukhari versus Brij Mohan Ramdas Mehra clarified that an offer of bribe is enough to constitute to corrupt practice, irrespective whether it is accepted or not. Undue influence at an election. Corrupt practice under Section 123(2) of RP Act 1951. Electoral offence under Section 171(c) of IPC 1872. The Patna High Court in Gangaram Mishra versus Chedi Paswan and others declared the election of Shri Chedi Paswan to the House of People as void, as he had suppressed the fact about pending criminal case against him in his affidavit and held that the returned candidate had committed the corrupt practice. Disturbing a public meeting is an electoral offence under Section 127 of IPC, but not a corrupt practice under Section 123(2) of RP Act 1951. The most common form of undue influence is to force voter to vote or not to vote for a particular candidate or not to vote in an election at all by making threats of physical injury. It is not necessary that there must be actual threat of physical compulsion, but the method of threat must convey to the person concerned that the threat may result in injury to him is essential ingredient of undue influence. Undue influence by threat of divine displeasure or spiritual censure. For certain tribes, the cock forms a very important and integral part of religious ceremonies. A candidate whose election symbol was cock distributed leaflets urging voters to vote for cock, failing which they may incur the wrath of deities. So the Supreme Court in Subnath Deogam versus Ram Narayan Prasad held it corrupt practice under Section 123. Appeal on the ground of religion, race, caste, community, language, etc. The Supreme Court in Jagdev Singh Siddhanti versus Pratap Singh Daulta clarified that political agitation for the conservation of language of a section of the citizens cannot be regarded as a corrupt practice. But when an appeal is made to vote or refrain from voting on the ground of the candidate's language is a corrupt practice under Section 123. Hate speeches. The Supreme Court identified various provisions in the existing law to curb the menace of hate speeches at all times, including the election period. The sections of different acts are shown on the screen. Propagation or glorification of practice of sati. New ground of disqualification from 1987. Corrupt practice under Section 123(3) of RP Act 1951, imprisonment for 6 months. Publication of false statement. Corrupt practice under Section 123(4) of RP Act 1951. Electoral offence under Section 171G of IPC 1872. The Supreme Court in Subhash Desai versus Sharad J. Rao observed that there should be a delicate balance between the freedom of speech and the interest of the public to get full information about the candidate, but not to affect the prospect of the candidate concerned by publishing facts about his personal character or conduct which are false. In T.K. Gangi Reddy versus M.C. Anjaney Reddy, certain leaflets were published a few days before polling and referring to a murder which had taken place earlier in an attempt to throw the blame for the murder on the respondent. The publication of such leaflets was held by the Supreme Court as an attempt calculated to prejudice the prospects of the respondent's election, as such publication was calculated to create an impression in the minds of electors not to vote for the respondent, who was described as a murderer and a man of bad antecedents. Free conveyance of voters. Corrupt practice under Section 123(5) and 133 of RP Act 1951. Electoral offence under Section 171C of IPC 1872. In Umaid versus Raj Singh, a truck bearing the flag and symbol of the candidate was found being used for taking some voters from a village to the polling station, and the voters stated that they had not paid any money for their transportation. The SC held it as a corrupt practice under Section 123(5). Incurring of election expenditure in excess of prescribed limit. Corrupt practice under Section 123(6) in contravention of Section 77 of RP Act 1951. Electoral offence. Failure to maintain the election account under Section 171I. Illegal payments in connection with an election under Section 171H of IPC. The Honorable Supreme Court in L.R. Shivram Gode versus T.M. Chandrasekhar has observed that the ECI can go into the correctness of the account of election expenses filed by the candidate under Section 123(6) of RP Act 1951 and disqualify a candidate under Section 10A of RP Act 1951 in case the account is found to be incorrect or untrue. Obtaining of assistance of government servants. Corrupt practice under Section 123(7) of RP Act 1951. In Narendra Singh versus Mala Ram, the SC held that the improper rejection of nomination papers by the returning officer does not constitute corrupt practice under Section 123(7) of RP Act 1951. In Deepak Kumar Das versus Mrinal Kanti Ray, the Calcutta High Court held that any irregularity by the returning officer in the counting of votes could not be regarded as a corrupt practice under Section 123(7) of RP Act 1951. In Lakshmi Narayan Nayak versus Ram Ratan Chaturvedi, the Supreme Court held that officers deployed for maintaining law and order could not be regarded as a corrupt practice under Section 123(7) of RP Act 1951. Booth capturing. Corrupt practice under Section 123(8) of RP Act 1951. Electoral offence under Section 135A of IPC. Any act by any person in the service of government of all in the furtherance of the prospects of the election of a candidate at the polling station comes under the Section 135A of IPC. Booth capturing has an extended meaning so as to cover even the rigging of the counting process at the counting places and not merely the polling process at the polling station under the Section 135A of IPC. Electoral offences. Electoral offences are specified in Indian Penal Code, Representation of People Act 1951 at the stage of conduct of elections, Representation of People Act 1950 during preparation, revision and correction of electoral rolls, the SC and ST Prevention of Atrocities Act 2015. Electoral offences under the IPC are enumerated in Chapter 9A under the heading of Offences Relating to Elections. This chapter was inserted in 1920. Recognized by the IPC. Bribery at elections, Section 171B. Undue influence at elections, Section 171C. Personations to elections, Section 171D. False statement in connection with an election, Section 171G. Illegal payments in connection with an election, Section 171H. Failure to keep election accounts, Section 171I. Electoral offences under the RPA 1950. Malpractices in relation to electoral rolls. Making false declarations, inclusion of ineligible names or deletion of eligible names by false statements and declarations, non-cognizable offence, imprisonment up to 1 year or fine or both. Breach of official duty in connection with electoral roll, non-cognizable offence, imprisonment not less than 3 months and up to 2 years and fine. Electoral offences under the RPA 1951. Malpractices affecting free and fair elections, promoting enmity between classes in connection with election, Section 125, filing false affidavits, etc., Section 125A, holding public meetings during period of 48 hours ending with hour fixed for conclusion of poll, Section 126, restriction on publication and dissemination of result of exit poll, etc., Section 126A, offences by companies conducting exit polls, Section 126B, disturbances at election meetings, Section 127. Printing of pamphlets, posters, etc., without printing the names of publishers, printers, etc., Section 127A. Violation of secrecy of voting, Section 128. Officers, etc., at elections not to act for candidates or to influence voting, Section 129. Canvassing in or near polling station, Section 130. Disorderly conduct in or near polling station, Section 131. Misconduct at the polling station, Section 132. Failure to observe procedure for voting, Section 132A. Illegal hiring or procuring of conveyance at elections, Section 133. Breaches of official duty in connection with elections, Section 134. Government servants not to act as election agent, polling agent, counting agent, Section 134A. Going armed to or near a polling station, Section 134B. Removal of ballot papers, etc., from polling station, Section 135. Booth capturing, Section 135A. Non-grant of paid holiday to employees on the day of poll, Section 135B. Sale, distribution, etc. of liquor on polling day, Section 135C. Fraudulently tampering with nomination papers, ballot boxes, ballot papers, election records, etc., Section 136. The conviction for Section 125 is imprisonment up to 3 years or fine or both, and disqualification for membership of Parliament and state legislature for a minimum period of 6 years from the date of conviction, disqualification for voting for 6 years. Conviction for Section 135 is imprisonment up to 1 year or fine up to ₹500 or both, disqualification for membership of Parliament and state legislature for a minimum period of 6 years from the date of conviction, and disqualification for voting for 6 years. Conviction for Section 135A is for any person, imprisonment not less than 1 year, which may extend up to 3 years, and fine. For government servant, imprisonment not less than 3 years, which may extend up to 5 years, and fine. Disqualification for membership of Parliament and State Legislature for a minimum period of 6 years from the date of conviction. Conviction for Section 136(2) is imprisonment up to 6 months or fine or both, and disqualification for membership of Parliament and State Legislature for a minimum period of 6 years from the date of conviction, and disqualification for voting for 6 years. Conviction for Section 125A is imprisonment up to 6 months or fine or both. For Section 126, conviction is imprisonment up to 2 years or fine or both. For Section 126A, conviction is imprisonment up to 2 years or fine or both. For Section 126B, conviction is punished accordingly. For Section 127, conviction is imprisonment up to 6 months or fine up to 2,000 or both. For Section 127A, conviction is imprisonment up to 6 months or fine or both. Conviction for Section 128 is imprisonment up to 3 months or fine or both. Conviction for Section 129 is imprisonment up to 6 months or fine or both. For Section 130, conviction is fine up to Rs 250. For Section 131, conviction is imprisonment up to 3 months or fine or both. For Section 132, conviction is imprisonment up to 3 months or fine or both. For Section 132A, conviction is imprisonment up to 3 months or fine or both. For Section 133, conviction is imprisonment up to 3 months or fine or both. For Section 134, conviction is fine up to Rs 500. For Section 134A, conviction is imprisonment up to 3 months or fine or both. For Section 134B, conviction is imprisonment up to 2 years or fine or both. For Section 135B, conviction is fine up to Rs 500. Conviction for Section 135C is imprisonment up to 6 months or fine up to Rs 2,000 or both. Conviction for Section 136(1) for RO or ARO or PO or any official in connection with election is imprisonment up to 2 years or fine or both. For any other person, imprisonment up to 6 months or fine or both. Electoral offences under the SC and ST Prevention of Atrocities Act 2015. Whoever, not being a member of SC or ST, forces or intimidates or prevents a member of SC or ST in connection with election or voting, imprisonment not less than 6 months and up to 5 years, and fine. If you have any doubts or want any clarification, you can contact through the mail address shown on the screen. For other election related videos, you may visit the web address as shown. Thank you.